So I met this beautiful couple. I met this beautiful couple just a month back, and just 2 weeks back, I found out she was a lawyer. And at the first time, I just asked her, and bam, she agreed to do the session. So it's very difficult to find good-hearted lawyers in Goa right now, but I'm so happy she's here with us, and she's doing this beautiful session on making a will. Now, you can ask, let her do a session, let her explain a couple of things, and after that you can ask her questions. If there are any questions, unfortunately she has to leave a little bit early as well. If there are any pending questions, she's happy to address them in the next session. So over to you, Rifka. Let me introduce Rifka to Memory Cafe, and Memory Cafe to Rifka.
Thank you, Sheldon, for your kind words as well. Hi, everybody.
Hi.
Today I'll be speaking about the will. Now, what exactly is a will? Most of you all must have heard this term, will and succession deed and all these terms. But what exactly is a will, and why is it so important that a person makes a will? So, a will is nothing but a legal document that states the wishes of a person making it, and that person is a testator. So the reason is that a person makes a will basically so that there is no confusion after his death. So it states his wishes, and the person making the will is known as a testator. So the will states the wishes of a testator after his death. It basically states the distribution of his assets, his property, his money, and also in case there are minor children or unwed children, mentally disabled children, uh, all this is also stated in the will as to what exactly will go for them. Now, a will is very important for succession planning, which ensures that after the testator's death, there are no disputes among the legal heirs. We see nowadays so many disputes with regards to property and money and everything once the head of the family passes away, which is very sad because there are so many fights between siblings, as to who will inherit what. And it gets very disheartening actually to see families break over these kind of things. So a will basically paves the way so that no disputes arise. Now, the will names an executor who is entrusted with the duty to carry out the wishes of a deceased testator. Now, appointing an executor is not really important, but in case the person, the testator, wishes to appoint somebody whom he trusts, like a trusted advocate or a friend, to um, carry out his wishes after his death, he may appoint an executor. And the will provide the executor with instructions on how the estate, the property, the money, whatever the assets is, and the likes has to be distributed among the heirs. So it is very important that while making a will, the testator is of sound mind. Now, what do we mean by sound mind? Firstly, a person understands that he or she is making a will and should most importantly know what exactly a will is and why the person should make a will. Secondly, the testator should fully understand his relationship with those people who are mentioned in his will. He can't just, pick on any Tom, Dick, and Harry. He has to have a special relationship with them to actually make the will and, incorporate their names in it. The testator also has to have full knowledge and understanding of what type of property he owns. He cannot make a will on property which is not his own, on property which is disputed. He can only make a will which includes property or money or estates or whatever, which are his own and which he has full possession of. And he needs to know how he is going to distribute the said property, or how the said property will be distributed on his death. Now, just because one is making a will does not mean that a person is going to die immediately. People make wills in anticipation to avoid any confusion later on when he is no more. Because of this, a will must be reviewed from time to time to ensure that it still meets the needs of a testator. Because a person can make a will today, but maybe 2 years down the line, he realizes that what he has written over there does not hold uh, important now, and he wants to change certain things. So that's the reason why the will needs to be reviewed from time to time. It is especially important to review a will in the following events. Now, when do we actually review a will? So, if the testator is a single person and he gets married, or if he remarries, or if he divorces, now this may actually void the will that was made earlier, you know, based on these situations. And if there is a significant change in the amount of money, property, or both that he owns, then again the will have to be rectified. Now, if the executor or a significant beneficiary in the will dies, then again it will have to be revisited. If there is a birth or an adoption of a child in the testator's family, that's another reason uh, why the will has to be rectified. And lastly, if the testator changes his mind about the provisions of the will, if he suddenly feels that, you know, certain clauses in his will, he doesn't want to have certain clauses in his will, or he wants to cut out somebody's name in the will or add somebody's name, that's when again it will be revisited. So you kind of get a picture on what a will is and what it entails. Now, how do we use this legal document? Basically, the will. In order to be valid, a will does not have to adhere to any specific form, format, or language. What is the most important thing in a will is that it discloses the intention of the testator who wishes the way of disposing of his assets after his death. Now, a typical will usually provides that all the debts of the property, including the taxes, should be paid first before it is divided. Though, of course, this we do on a regular basis and it is payable by law, so we cannot really escape that. Now, will would also state the name of the executor or the executors who will be responsible for administering the property, and then would set out his powers as well. As in, the will state the name of the executor and what exactly he is supposed to do in order that the assets are distributed without any bias. Next, a will would state any specific assets or property or money that are to be distributed to the legal heirs. Now, whatever is left after all the special gifts are given and after all the debts, if any, have been paid, that is called the residue of the property. Therefore, we see that a will in certain circumstances would contain a residual clause, which would specify how these residue assets need to be distributed. Now, for a will to be formally valid, firstly, it must be signed by the testator, and there should be two witnesses at the same time uh, in the presence of each other. Now, according to the Indian Succession Act, some religious or personal laws also come into play in respect of the assets which can be given away through a will. And these would be governed by the Muslim Personal Law or the Hindu Succession Act. Now, we will not really get into all that. We will see about Goa and how we go about making a will and the rule um, that helps us in making a will. Because here in Goa, we have something known as the Uniform Civil Code. And this gives equal rights to both men and women. And it is applicable to all religions. This privilege is only limited to the state of Goa, though now we see on the newspapers that other states as well want to incorporate, this uniform civil code so that, everybody gets equal rights. Let's see how far that goes. But this privilege that we have here in Goa are only for the Goans, those who are born here, and it has been in force since pre-liberation, and thus we Goans have inherited this uniform civil code, which brings a unique distinction to our beautiful state. Now, moving on. Under this uniform civil code, we see that a married couple jointly holds ownership of all the assets owned before the marriage or acquired after the marriage by each spouse. And in case of a divorce, each spouse is entitled to half the share in the assets unless the marriage has been termed null and void for legal reasons. For example, um, non-consummation of the marriage, deception on either part, that is by either party, insanity, domestic violence, etc. That again will be decided by the family court. Now, while making a will here in Goa, the husband, who is the head of the family, will be the main testator, and his wife will also be required to give her consent. Um, and this will be done through another document which will be attached to the main will. This then will be signed by two witnesses in the presence of a sub-registrar under the Indian Registration Act. And registering a will not only safeguard the will and its authenticity, but it would also prevent the will from being challenged after the death of the testator, which is again very important because we see that all the problems arise once the main person is dead. That's when all the problems start cropping up. Now, the process of writing a will can also be video recorded in certain cases, and the said recording of the will is admissible. That is, it will be allowed as evidence in court under the Indian Evidence Act. Now, if a will is going to be recorded, there is a specific format which has to be followed. I'll just give a brief on this. First of all, the title of it will be Last Will and Testament, and it will require the following. Firstly, the place and the date where the will is going to be signed by the testator, the full name of the testator, his age, his gender, his father's name, his marital status, religion, nationality, and full address. Next, the name of his spouse, the number of children, alive, dead, married, unmarried, disabled, as well as his grandchildren. If the testator has signed and registered any other will which has been previously made with the sub-registrar, then the details of that registration will have to be, submitted, or will have to, he will have to give the details of that so that that is nullified and the new will can be created. And the testator also is given an opportunity to nominate or appoint an executor. As I said earlier, this is not really required. It is not mandatory. But if you wish, you can appoint an executor. And if he wishes to appoint an executor, then all the details will be required to be stated and recorded. Now, when we spoke about beneficiaries, in the will, there are three types of beneficiaries. I won't get too much in depth. That's a primary beneficiary, the contingent beneficiary, and the residual beneficiary. So a person or an organization who will receive the assets, etc., on the death of the testator is called the primary beneficiary. A contingent beneficiary is a second in line who will be entitled to receive the stated assets in case the primary beneficiary passes away. And lastly, the residual beneficiary, here the person would receive any property that is not specifically left to any particular beneficiary or person. Sorry?
This is something about will.
Will, yes, yeah. Now, I'll just tell you about three things. That is the succession deed, the inventory proceeding, and the property inheritance law in Goa. Now, these are three separate topics which are vast and cannot really be covered in such a short span of time, but they are kind of linked to making a will. So when we come to inventory proceedings, we see that this is a process to partitioning the inheritance of a deceased person or obtaining a formal order of allotment of inheritance by the court. So if an inventory is done, it gives the proper what you say the direction of the partition of the property so that there is no no confusion as far as the partition of the property goes. Now succession, this is the transmission of the property of a deceased person in favor of his successors. So here the entire the family tree is taken and the successors are all found out, and the reason for this is that nobody is left out from the division of the property, because sometimes what happens is when people go to make to do an inventory or to make a will, they conveniently leave out certain people of the family, somebody whom they do not like, somebody whom they have never who has kind of cut ties off with the family, or some uh, somebody who has not really gone by their ways. So all these things come in the picture here. So in order that nobody is left out from the inventory proceedings, a succession is made. So we first make a succession deed, then we go in for inventory. Now property inheritance law in Goa, here how it is relevant to a will is because a married person cannot sell off his property without the consent of his spouse, and parents cannot disinherit their children entirely. At least half of the property has to be passed on to the children compulsorily, and the inherited property must be shared equally amongst the children. So this largely helps when making a will, and yeah, it kind of gives you the directives what you must follow when actually making a will. So that's about it where the will is concerned. So anyone would like to ask me any questions or any clarifications? The topic is very vast. I've just tried to summarize the whole thing. I hope I've been successful in summarizing it and making it a little easy to understand.
Put your hand up. Can the executor be a member of the family? Has to be an outsider.
No, the executor cannot be a member of the family. The executor has to be a non-biased person. So even a family advocate, mostly in Goa, what we do is, since everybody knows everybody, the testator appoints the family lawyer to be the executor. That's what happens here in Goa. But not necessarily an executor is appointed only when the family is really large, and an executor is really required. In smaller families, they just make the will directly and yeah, and go about it. So.
May I ask?
Hello. Grandchildren
Yeah.
have rights
You spoke about
when the children are living.
Yes.
Do grandchildren have rights when the children are living?
Here again, if the children are living and the grandchildren want to claim anything, it is only the parents have to actually give an application stating that they would like to put in their children's names, grandchildren's names, whatever, and then again a division is made, which is, equally divided among how many grandchildren are there. So, yeah.
Okay.
Yeah.
Does this uniform civil code apply only to persons born in Goa?
Yes. It is applied to
born.
person only born in Goa. You've got to be a true blue Goan, not just, come from somewhere and say, I'm a Goan. Not that. You need to be born here. Your parents have to be born here, your grandparents. So it's kind of come down, through the ages, because this law was actually first made by the Portuguese. So it's come from there.
And
So
My parents were born here
yeah.
and grandparents as well, but we
Yes.
were not born here. So what happens now?
You will still be able to get part of it, as in the will has to clearly state all that. You will need to go to the registrars, the sub registrars, and produce the documents which show that show who your grandparents are, when they were born, your parents. So as long as you have your documentation in order, you can claim part of the property, which
Oh, we
is
want to
of course.
claim, we want to give. I mean, we're not claiming any property. We are,
Sorry, I didn't get
we're
you.
not claiming any property. We want to make a will to give our children
Yes.
property when they die. So can we divide our property among the children according to the uniform civil code?
Yes, of course. Yeah. You are living here in
Born.
Goa, right?
Don't have to be born
So
in Goa.
automatically it will be done as per the Uniform Civil Code.
Okay.
And
Yeah.
suppose there's a couple where, say, the wife is born in Goa and married to somebody from outside Goa. What about their children?
In this case, they will not be considered. The wife, I mean, only the wife's share of the property will be divided. But not the husband will not really have, any right over here, unless and until he can show that he has been a resident in Goa for a couple of years and things like that. So by marriage, he might be able to get part of it, but the children, yes, the children will be able to inherit the property from the mother.
Okay. Thank you.
You're welcome.
If you just write out a will, and it's not registered, is it valid?
No, a will has to be registered. See, there are wills which are not registered, but what happens is when the person making the will, that is the testator, when he passes away, that has always been challenged in court. And it has been proved that that particular will is not, standing and does not have any legal standing. So that's when all the confusions again start. So it's always good to safeguard your will by registering it with the sub-registrars.
Well, we have registered our will some years ago, but we may have to make some changes. So we can just go ahead and make the change, and the other one will be null and void.
Did you all make the will through an advocate?
Yeah, to an advocate, right?
Yeah, so then you can go
then
back to the advocate and tell him that you need to make a couple of changes. So then he will apply to the sub-registrar, and that earlier will be nullified, and then you all can, make the new will. Or if it is a minor change, then just an annexure can be attached to the earlier will.
Which we can do on our own. We have to still go to the registrar for that?
Yes, you have to go to the registrar. Because it has to be, it has to be mentioned in the
Again.
books over there, the change and things like that.
Okay, all
Yeah.
right. Thank you.
You're welcome. Any other questions?
Yeah, I wanted to know in the inventory, say, say you got some mutual funds or something.
Yes.
Value is changing, so you just have to mention the mutual fund itself, or you have to mention the value.
In a will, you have to mention everything. So if there is a major change, as I said earlier, if there is like a major change, then that will have to be added to your existing will. And the sub registrar will decide if the will, because if it's just a, just a portion, then you can just put an annexure saying that, this was the change or whatever. When I first, made the mutual fund, it was this much, but now it is this much, whatever. So just that part can be annexed to your original will. But if it's something that is huge, if there is a huge kind of a change, only then the earlier will would be nullified and a fresh will be made.
So in the will, the quantities we mentioned, right? Say I got a
Yes.
mutual fund in a particular company,
Right.
and I got another company. The value on the particular date of the will has to be mentioned in there.
Yes. Yeah,
But
definitely.
it'll keep on changing, no? It cannot change.
Yeah, it keeps on changing. So that again can be added in a clause in the will itself, stating that, year by year the value changes and things like that. And the percentage can be mentioned on the will.
Okay.
Yeah, sorry.
What happens? Mine is a different question. What happens if the husband is a Goan but the wife is not?
If the husband is a Goan, again, there is not much of a problem because
Okay.
he is the head of the family and he is
Okay.
the one who's making the will. So he's the
Okay.
main guy. So he's the testator and he's
Hmm.
married to a lady who is not from Goa. So, but by marriage, she becomes, a part of that family. So in that
Okay.
case, it is pretty clear cut. It will go as per the Uniform Civil Code itself.
Okay. Thank you.
Yeah.
Suppose in a will, say I'm talking about a bank, say FD.
Yeah.
Okay. The nominee is mentioned in the will as a certain person. Sorry, the nominee in the FD is mentioned as a certain person,
Okay.
but in the will, the person who's supposed to inherit that is different. Which one will hold good?
Now, this is a very dicey situation here because ideally the nominee's name also has to be mentioned, but as per the rules of the bank, the benefit will be given to the nominee. And probably they would divide it. I'm not very sure about this, but I can definitely find out and let you know on this. Because a will has to state every person's name. A will cannot have one name and, then you have some other document stating somebody else's name. So what is in the will? Because the person is actually saying that, so and so needs to go to so and so. So that will go to that person itself that way.
Okay.
Yeah.
Oh, thank you.
You're welcome.
And supposing a person has two properties, can they give one to one child and the other to the other child?
Yes, definitely. Why not? Because
Even if
here
the-
the
even if-
question of inventory and succession comes into play.
Yeah, even if the value is different?
That doesn't matter. Because
thanks.
actually, see, it's not that the value is different or anything. It's you have two properties. Now you're not taking when you're making a will, you're saying property A and property B. Now
Yeah.
you've got two children. They are both legally yours, right? I mean,
Yes.
they're biologically yours.
Yes.
So the value of the entire thing will be equally distributed between the two.
Okay.
So whatever distribution happens has to be equal if you're doing it here in Goa.
Okay.
If a will was to be made in Bombay or any other place, then if you have, say, a flat and if you have a piece of land and you want to give the apartment to your daughter and the piece of land to your son, you can still do that. But here in Goa, what is important is that the inventory is done of the entire thing and it is equally distributed amongst all the children.
Okay. Okay.
Yeah.
But when if you got two flats, say,
Yeah.
one is a little more, one is more valuable, one is less, then what happens?
That becomes as I said earlier, it becomes a special gift.
Okay.
So you can also make a gift deed, which can be attached to the will, wherein you say that, you would like to give this to so-and-so and this to so-and-so. Yeah. So a gift deed would have to be attached to this.
Okay.
As I said earlier, a will, what I've told you is just a skeleton of, what a will is. But there are so many things which actually go into making of the will. Like you've got to have if you're a big family, if you're a small family, like with one child, you don't really have to do much. But if the minute it is two or more children, then you have to have the inventory, the succession, the gift deed. There are properties which are bequeathed to certain parties or institutions. So all that has to, your documentation basically has to be ready to make that will.
Okay.
Because a will can be from like 1 page to like a whole 50-page document. So it's that way. Yeah.
Okay. Thank you. Okay.
Can a gift deed be contested by the siblings?
A gift deed cannot be contested because it is a gift. So you cannot really contest. But if it is, if you have given a gift to somebody who is not part of the family and have not put in a public notice stating your intention to gift that to somebody who's, not part of the family, then yes, the person can contest.
No, because I'm very confused about some say I have to get a renunciation letter.
Sorry, I didn't get you.
I'm very confused because some lawyers say I need to get renunciation letters from the siblings.
Your voice is breaking. I'm not getting you.
Some lawyers say I have to get a renunciation letters from the siblings.
From the
siblings.
From the siblings. This is in case of a gift deed, you're saying.
Yeah.
But
you want to know? I say that.
Sorry.
That is what I want.
Do I need the renunciation letters?
No, I'm not getting you. I'm just hearing some sounds.
He says that the lawyer says that if you're giving a gift to somebody else outside, you have
Yes.
to get a renunciation letter from the
Yeah,
sibling.
you will have to get it. It's basically like an NOC that your siblings do not have any, problem with you gifting a particular thing to somebody out of the family.
But it has not been contested for so many years. Can they contest at any time? That's
Can they? But were the siblings informed about it?
Yeah, they were informed.
They were informed, and is that documented?
Yeah, documented.
Then there shouldn't be a problem, right?
So I need not.
No, then I mean, like you have gone as per the rules, so you don't have anything to worry about. As in, you're not answerable to anybody for this because you have already got the NOCs from your children, and they have agreed. The minute they agree, they renounce their willingness to that property or whatever the asset may be. Yeah.
Coming back to the bank FDs,
Yeah.
suppose someone has, say, about 7 or 8 FDs. Can you make one statement saying that I would like all the FDs, the proceeds of all the FDs, to go to the respective nominees? Or do you have to mention the individual names of the nominees?
No, you in your will you have to mention the names. It's very important that you mention the names so that there is no confusion. There have been cases wherein general words like nominees and successors or my heirs, these kind of generic terms are used, and that's when all the problem arises. So the minute you put in the name, it's very clear cut who gets what, that kind of thing. Yeah.
Okay, thanks.
Excuse me, I'm from Goa, and
Yeah.
my parents and grandparents are also from Goa, but at the moment living in Bombay.
Okay.
So will my property be given to the siblings or my children according to Goa rules?
Yes, because the property is in Goa, right?
No, the Bombay. The property is in Bombay.
The property is in
I'm
Bombay.
Goan,
Okay.
and my ancestors are also from Goa.
But the
So
property is
does
in
it-
Bombay.
Bombay, yeah.
So then it will be governed by the rules of Bombay, not the
Bombay.
Uniform Civil Code. Yeah. If the property was in Goa, then definitely.
Okay.
Like
Thank
you can be anywhere in the world, but if your property is in Goa, then the division will be as per the rules here in Goa.
Okay. Thank you.
Yeah.
Excuse me, I didn't understand what is
What is that?
Primary beneficiary.
Yes.
And contingent beneficiary.
Yeah. Now, primary beneficiary is basically a person or an organization who receives the asset. Like for example, in the will, if a person say donates a part of his land, say to the church, so but say the organization or that particular church ceases to exist, or there are some legal complications over there, or the person whom he wanted to gift that land for whatever reason dies, then the next in line would get it. You know,
Okay.
so like for example, say a charitable organization. If a person wants to donate money or donate a land or donate a space, whatever it might be, to a charitable organization which is run by Mr. X, and it so happens that Mr. X passes away, then the next in line, who is also a part of that same charitable organization, will be entitled to get that asset.
Okay, thank you.
Okay, we'll have to end. We'll have to end right now because Rifka also has to go. But thank you, Rifka, so much. I'm sure that if
Thank
I
you.
didn't end this, they would keep you till 8 o'clock. All the questions. Okay.
If there
But,
are any questions or you have any doubts, you can always message me and I'll, get back to you on whatever it might be.
Thank
Not
you.
only in relation to a will, but if there are any doubts in your mind about any part of, these kind of property issues and things like that, then please feel free to contact me either directly or through Sheldon.
Okay, then. Sure.
Rifka, you've opened Pandora's box for yourself. I hope you have to keep the whole December month free now for answering calls. Anyway, thank you, Rifka, so much.
Thank you for having me, Sheldon.
And sharing your knowledge. I'm sure all the seniors really have taken something back. As Rifka has opened up, if in case I'll be sharing Rifka's number on the WhatsApp group. Yeah, I would say you have trouble her to can trouble her to get an answer of whatever is keeping you awake at night. Thank you, Rifka. Thank you.
Thank you.
And,
Thank you for having me.
Also,
very
on
much.
way of ending.
Thank you very much. Thank you.
Thank you. Thank you.
Thank you.
Thank you very much.
Thank you. Thank you.
You're
Bye.
welcome. Thank you so much. Yeah.
Thank you very much.
We can also end. We can also end the year along with tying up all the loose ends with a smile on our face and a tap on our feet. So let's everybody get up and practice the Mary's boy child Jesus Christ, right? Sabrina?
Okay.
Yeah, sure.
Thank you, Rifka.
Thank you so much. Yeah.
Yes. Very informative. And I'm sure everybody can, once they tie up loose ends, they can have a peaceful new year. So that's fine.